I'm sure that sound's going to bother you. Anyway, good morning. Happy Friday. A couple things I want to address. Number one, why do I record in the car? I get this comment a lot. I don't know why I get this comment. Number one, it's comfortable to sit in the car. Number two, it has good acoustics. Number three, it doesn't bother other people if I am at an office where there are other people. I do work at two law firms, plus I have my own practice. So I don't want people to have to listen to me babbling on about some arcane subject while they're trying to do legal research or talk to clients or what have you. So that's that. And then if I'm in my own office, I have done one video out of my office. It was a short video. I think it was called Twist of the Knife or something. And people are like, oh my God, the audio quality is terrible because my office echoes terribly. Okay. And it's got a vent up in the corner that just screams as it tries to pump air out, because every other office in that building has their door closed. The return on the air conditioning or heater unit is in the hallway. The sensor for the temperature is in the hallway. So every single office has air just pumping as hard as possible into it because it's got to get past the doors and try to heat up or cool down the sensor in the middle of the hallway. So it sounds like I'm in a wind turbine, wind tunnel, wind turbine, whatever. You get the point. This is just a much more convenient place to record a video. If you don't like it, I'm sorry, move along. As far as the actual subject of this video, vexatious litigant status, I have been bombarded with insistent comments about, oh, Chillie is a vexatious litigant. Chillie's being a vexatious litigant. How much longer until Chillie gets declared a vexatious litigant? Should Kate and Josh file a motion to declare Chillie a vexatious litigant? It doesn't work that way, or at least my understanding of it. Let me just rephrase that. My understanding of it is that it doesn't work that way. Currently, Kate and Josh are in a federal court, so federal law is going to apply. I believe it would be 28 USC 1651, the Writs Act, WRITS, like a writ of mandate or a writ of prohibition. What essentially has to happen, in my understanding, is that in that particular district court, Chillie would have to file at least 3 lawsuits that were each found to be filed frivolously. At that point, the court, i.e. a judge in that court, could issue a writ, like a order to show cause kind of writ, to Chillie, giving him notice and an opportunity to be heard about getting declared for that court system a vexatious litigant. I don't know if federal courts share their vexatious litigant lists. I know California does. Like if you get declared a vexatious litigant in Los Angeles, then San Francisco is also going to treat you as a vexatious litigant. But anyway, you need at least three instances where your lawsuits have been determined to in that system. In that system, you have 3 where you've been determined to be a vexatious or a frivolous filer. So you get your notice and opportunity to be heard. And if then the court finds that you haven't shown why you shouldn't be a vexatious litigant, then at that point you can still file lawsuits. I mean, you have a right to petition the government for redress of grievances, and one of those ways is by filing lawsuits. You could petition the government to redress grievances, not just your grievances with the government, but your grievances with your fellow citizens or other people in society at large. So what has to happen is that you basically have to submit your proposed complaint to the judge, to a judge, or maybe the presiding judge in that particular district. And that judge would then have to determine whether or not there's merit in what you've filed. Just based on your pleading, not looking at any other facts, just based on your pleading, is there merit? So if you look at Chillie's pleading, or at least his original pleading, based on his pleading, it doesn't really look frivolous, because he says in his pleading that he has not been, never done anything with GHP. He's saying that all these things are lies. And so And so from his pleading, it does not look like it's frivolous. Now, at the end of this, the judge may find that it's been frivolous, because I'm sure that just like the court in Massachusetts found out about his criminal record, I'm sure the federal court is going to find out about it. And if the federal court doesn't have the power to get it on its own, if it doesn't have access to those same records, which I believe they do because it's all reported to some federal reporting system, but Kate and Josh's attorneys can request the court take judicial notice of these various convictions and arrest records and things like that they have. So at the end of this, he might be found to be or he might be found to have made a frivolous filing. Might. But that would only be one strike against him out of 3. So vexatious litigant, if it ever comes, is a long way off. So let it go. Was that LC from Frozen or whatever? Or start singing Let It Go? Just let it go. Let vexatious litigant go. Best case scenario for Kate and Josh is that the court finds that this pleading is frivolous and the court awards sanctions to them based on this pleading, or the court issues sanctions that are paid to the court for this pleading. That's best case scenario for this pleading. Probable scenario is that Kate or Josh or both are going to file a 12b6 motion for failure to state a claim upon which relief can be granted, yada yada. Basically, it's a adjudication that is based on the pleadings. At that point, I don't believe that Chillie is going to respond to their motion. He's simply going to file his amended complaint. At which time, my best assumption is that he's not going to know what to fix or how to fix it, because all the dude knows how to do is file complaints. He doesn't know how to defend them. They're going to file another 12b6, and we're going to march right back into court. Chillie's not going to know how to defend it. He's probably going to ask for another bite at the apple to amend his complaint. The judge will probably grant it, because he is a pro se. And so the judge will probably grant him one or more additional opportunities to amend his complaint. My best guess is they will each be tragically flawed because he doesn't have a good cause of action, and they will each fail to a 12b6 until at some point the judge is going to get tired of his shenanigans and say, look, you can't amend this to make it work. So it is now, I'm granting the 12b6. It's dismissed with prejudice, no leave to file an amended complaint. And then it's done at that point. That's the way I anticipate it going. Worst case scenario is this heads all the way to trial, which I doubt will happen. I doubt Chillie has the testicular fortitude to go through the discovery process. It's going to be long. It's going to be complicated. It's going to require him to produce a lot of things, to answer a lot of questions that he's not going to want to answer. He's not going to know how to deal with it. He's going to try to be evasive, and he's going to get called out on it. There's going to be motions to compel, and it's going to be stupid and ridiculous. And he's going to face sanctions for discovery, for failing to respond adequately to discovery. And it's going to be silly, but worst case scenario, this goes to trial. I believe that Chillie has requested a jury trial. A jury is going to find against Chillie because he doesn't have a good claim. So that's best case scenario and worst case scenario. There you go. Not a vexatious litigant, not close to it, not yet. He's going to have to be found to be frivolous this time, and then have 2 more times before the federal court, in my understanding, before the federal district court can label him a vexatious litigant for that federal district court, maybe for the federal system, but probably just for that federal district court. Anyway, thanks for watching. Have a great day.